Straight ahead on Law&Crime Daily. The Biden administration backs down on its vaccine and testing mandate. But is the fight over for good? Plus, from hero to star witness, we look ahead to the Waffle House shooting trial, who the prosecution may call. And from defendant to attorney, Michael Avenatti will represent himself in federal court. But first, closing arguments in Wisconsin versus Theodore Edgecomb.
When the victim said words, he punched him. When the victim gets ready for a fight, he kills him.
Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm Brian Buckmeyer along with Terry Austin. Prosecutors and defense attorneys make their final plea to the jury Wednesday with closing arguments in the case of Wisconsin versus Theodore Edgecomb. It was the last chance for Edgecomb's legal team to present its argument of self-defense. In September 2020, Edgecomb was riding his bike when he says immigration attorney Jason Clearman and his wife swiped him with their car, causing him to fall over. Video footage shows Edgecomb punch Clearman through his open passenger side window. After that, the car follows Edgecomb. On Tuesday, the defendant testified that he, quote, feared for his life when the couple followed him. Security footage shows Clearman get out of the car and confront Edgecomb. That's when he shot Clearman. After that, prosecutors say Edgecomb fled the state. He was arrested 6 months later in Kentucky. Ahead of closing arguments Wednesday, jury instructions were discussed. Judge David Borowski ruled jurors will determine whether Edgecomb intentionally shot Clearman or whether it was in self-defense. Jurors have several options to discuss in deliberations: Edgecomb's charge of first-degree intentional homicide or lesser charges like second-degree intentional homicide, first or second-degree reckless homicide, or negligent homicide. While the defendant has always maintained self-defense, he testified, quote, the gun just went off.
When he lunged forward, that's when I stepped back, and there was a reaction as far as like the gun just went off as far as when I stepped back, as he lunged forward.
If the gun goes off pointed down, how does Mr. Clearman get one in his eyebrow with only a slightly upward trajectory?
His head, he was like lunging towards me like he was gonna spear me or tackle me, and as I stepped back.
When you stepped back, did you pull the gun up?
Overruled. It's cross.
When you stepped back, did you pull the gun up?
At that moment, it did go up because I stepped back. It was reactionary.
Just a reaction. So you're stating you didn't mean to shoot him?
There was no intent there, no. I was...
Total accident, he got shot?
Yes, there was no intent there.
Thank you very much.
In Wednesday's closing arguments, prosecutor told jurors Edgecomb did not act in self-defense and highlighted evidence they say proves it.
4 people saw that gun in his hand. Not because it's down by the side and, oh, there's a lot item or they saw the gun. And what does the defendant do after that, ladies and gentlemen? He runs. And all we know is he never comes back. The gun that he used, according to him, he just throws it out the window because he, doesn't want someone to shoot him with it. Something that meant that he kept onto it, held onto this murder weapon for weeks through 2 states until all of a sudden he hits the cornfields of Indiana as though some voice comes out and says, if you ditch it, they won't find you. And then, ladies and gentlemen, it's all, oh, the victim must have had a knife. And when that falls apart because their witness doesn't see anything in the wife's hands and there's no evidence to support he had anything, not one single witness supports that, all of a sudden, at the 11th hour, we go from, yep, I was defending myself to it's an accident.
During the defense's closing, court was interrupted when a juror got sick. Closing continued with Edgecomb's legal team countering the prosecution, saying the defendant was trying to stop Clearman from hurting him.
Now the state would say, oh, we can't trust this testimony. Well, let's talk about his testimony. You heard him come on this stand and say that if I could do this over, yeah, I was upset. Yes, I was infuriated. But if I had another chance to do this, I would simply accept being hit by a vehicle, thrown into another, and being called a If you recall on cross-examination, he talked about, the gun went off after he lunged at me. You recall that? He said it a couple times. Mr. Edgecomb believes that he's already made it clear that he shot Mr. Clement. He intended to shoot Mr. Clement to stop a threat. He did not, however, intend to kill someone.
Joining us today is legal analyst Kirk Nurmi and Terry Austin. Kirk Edgecomb testified the shooting was unintentional. Now there are arguments that self-defense shouldn't apply. Does it?
Well, he certainly didn't do himself any favors in saying things that way, because self-defense is an act of justification. You're justified in taking that life because yours are threatened. It has nothing to do with accident. So probably from a strict legal perspective, you could make the argument that no, the self-defense doesn't apply given that testimony. And after we heard jury instructions, we heard that good back and forth between the attorneys making that point. And fortunately for Mr. Edgecomb, the judge was willing to let that in because there was some evidence to that effect. But yes, he was in the potential of losing that very valuable defense, the defense his attorneys had been asserting the whole time, because of his choice to try to alter his testimony maybe to what he heard or what his jailhouse lawyers told him.
Yeah. Now, Terry, it makes sense. Edgecomb's attorney probably said to him, if you don't understand a question, ask to clarify. But was it too much, and did it sound credible to you?
Well, I do think that his attorney probably instructed him and said, listen, if you don't understand, tell him to repeat it or rephrase it. But he did it a little bit too much. He just kept saying it, and it was very annoying, and I'm sure the jury was not happy about that. And so what I will say is I do think Mr. Lamar did a good job explaining at the end of the day why it was that Edgecomb was saying these things repeatedly. One, he has ADD. Two, he was very afraid because it's a serious case. And three, he was basically saying he was afraid of the prosecution.
All right, we'll see how this continues. The case is now in the jurors' hands as to whether or not Theodore Edgecomb is guilty in the killing of Jason Clearman or was self-defense. On to news out of Kentucky, where former Louisville police officer Brett Hankinson appeared in court ahead of his trial. Hankinson is charged with 3 counts of wanton endangerment in connection to the shooting at Breonna Taylor's apartment. Prosecutors say Hankinson endangered the safety of people in an apartment neighboring Taylor's. At a hearing on Wednesday, both sides argued over media coverage of upcoming jury selection.
The public can't be prevented from physically seeing the jurors. They will be sitting in the jury box during the trial in open court. And any suggestion that the public seeing the jurors is somehow going to destroy a fair trial simply can't stand up to that fact, that the trial itself has to be conducted openly.
I'm not asking that the media be barred from the hallway outside the courtroom or from the front steps of the courthouse. I just think that the media should not be in the courtroom influencing these jurors in a number of ways, in my opinion, mainly negative ways. Such that we can't get an impartial jury for Mr. Hankinson.
I think it's one thing for people to come down to the courthouse and sit in on a trial. It's a very different thing to be putting the jurors' images on the television. So I would be instructing the media to not do that.
In the end, Judge Smith ruled individual voir dire will not be completely closed to the news, media, or public. A lengthy jury selection process is expected to begin on Friday. Still ahead on Law and Crime Daily, years after the deadly Waffle House shooting, jury selection begins for suspect Travis REINKING. But first, disgraced attorney Michael Avenatti representing himself in the Stormy Daniels federal trial. Will you now question the prosecution's star witness? Welcome back to Law and Crime Daily. Co-host Terry Austin joins us now for the latest on a deadly shooting out of New York.
Brian, a second New York police officer has died from his injuries following a shooting last week in Harlem. Officer Wilbert Moore died Tuesday. He and his partner, rookie Jason Rivera, were shot while responding to a domestic incident. The mother of the suspected shooter, LaShawn McNeil, called police saying she needed help with her son. Police said a third officer shot and killed McNeil when he fired at Moore and Rivera. Detectives said they found an AR-15 under McNeil's mattress while searching the home, a different gun from the murder weapon. Mayor Eric Adams called for an end to the violence and said 5 officers have been shot recently.
It is our city against the killers. This was just not an attack on 3 brave officers. This was an attack on the city of New York. And it's an attack on the children and families of this city.
Officer Moore's organs were harvested for donation to help others. Brian, back to you.
Thanks, Terry. In a federal court, a shocking move as Michael Avenatti chooses to represent himself on charges he stole money from former client Stormy Daniels. On Tuesday, a judge ruled Avenatti could represent himself, meaning he will likely cross-examine the prosecution's star witness, Stormy Daniels. Daniels will likely take the stand later this week. Avenatti rose to fame while representing the adult film actress, whose real name is Stephanie Clifford. She accused former President Donald Trump of providing her with hush money payments to quiet news of their affair. Avenatti now faces charges for stealing $300,000 out of an advance for Daniels' memoir about her affair with Trump. Prosecutors say Avenatti forged her signature and later lied to her about where the money was going. An indictment says he used the money to pay law firm employees and for personal expenses like making a luxury car payment. If convicted, Avenatti faces 22 years in prison. Let's bring back legal analyst Kirk Nurmi and Terry Austin to discuss this major shift in representation. Terry, the saying goes, an attorney that represents himself has a fool of a client. Do you think that applies here?
I'm sorry. Yes, no question about it, Brian. I'm so excited about it. Yes, he's a fool for doing that. The old adage absolutely applies. First of all, you need the resources of an attorney to help you prepare for the case. They're going to do the research, they're going to do the openings and the closings. You know, second of all, it's the jury's perception that you think you know everything and you know so much that you can do it better than your lawyer could do it. And thirdly, in my humble opinion, I think that you're too personally invested when you're trying to represent yourself. It's going to be interesting to see him do it, but I think it's going to hurt the case at the end of the day.
All right, Kirk, so I'm not going to be representing myself for any future cases is what I've learned, but all eyes are going to be on Avenatti likely cross-examining Stormy Daniels. How's that going to work, and is there an advantage to being defendant and lawyer?
Yeah, certainly. Don't we all wish we had the cameras in the courtroom to see that cross-examination? And I think for the most part, Terry's right, but you know, regarding having a fool for a client, but you know, there's reports about his attorney, his public defender, doing 45 minutes of cross-examination on a witness. None of it, the judge said, was relevant, made the attorney sit down. So kind of in that instance, maybe this is a situation where it is wise for Mr. Avenatti to go forward. And while he's personally invested, that could be an advantage also in terms of his knowledge. He's going to cross-examine his own client, which again should make for great viewing. But also he's going to know things and be able to react to what she says quicker than a public defender who didn't have firsthand knowledge of it would. So I think the cross-examination could be that much more rigorous.
Agreed. I know part of this is that this is just simply a contract agreement that Stormy Daniels is kind of going back on. At least that's the argument. We'll see how it plays out. Coming up on Law and Crime Daily, the Biden administration drops its COVID vaccination mandate. What that means for you. Plus, jury selection is underway in the so-called Waffle House shooting. We look ahead to trial and who the prosecution may call as its star witness. Welcome back to Law and Crime Daily, day 2 of jury selection in the high-profile case in Tennessee. That of Travis Reinking, the accused gunman in a mass shooting out of Antioch Waffle House nearly 4 years ago. Reinking has pled not guilty to 17 counts, including first-degree murder for the shooting deaths of D'Ebony Groves, Joe Perez, Aquila Da Silva, and Teron Selderlin. It happened in the early morning of April 22, 2018. Prosecutors say Reinking fatally shot 2 people in the restaurant's parking lot before opening fire inside, killing 2 more people and injuring several others. After a 34-hour manhunt, Reinking was arrested. He faces life in prison. One man who was at the restaurant that morning, James Shaw Jr., stopped the gunman and in turn may have saved more people from being shot. He has been hailed a hero and could likely testify in the trial. Reinking was previously deemed incompetent to stand trial and was treated for schizophrenia. Jury selection, which started Tuesday, has been a difficult task given the media coverage of the case. Opening statements are set to begin on Monday. Legal analyst Kirk Nurmi and co-host Terry Austin join us again to break down the Waffle House shooting. Terry, I respect James Shaw Jr.'s opinion. I totally get it. But to me, he's a hero. So how do you think having a hero testify against a defendant will play out for Reinking?
Brian, there's no question that the jury is going to be very sympathetic. I mean, this man risked his life and he could have easily been killed. And I think it's the testimony that the jury is going to really admire. They're going to respect it. They're going to have sympathy. And when you compare that to the actual defendant who killed someone, I think the jury is definitely going to lean in favor, obviously, of making this individual guilty.
Absolutely. Now, Kirk, bizarre facts are likely to come out of this case. As you saw, Shaw Jr. had his hand wrapped there because the barrel of the gun was so hot it burned his hand. And Reinking was naked but for the jacket he had on top of him. How will these facts play into the case?
Well, I think ultimately, you know, because Mr. Reinking might be using some mental health defense, he's been treated for schizophrenia. Some of those bizarre facts could at least give the jury insight into that, the validity of that. But I think ultimately, you know, this is what we would call in the criminal defense business a long-form guilty plea, because we have so many witnesses against him. We have Mr. Shaw Jr., who stopped a potentially even more horrific scene. And I think the horrific nature of this crime, the extent of it, the extent of what could happen is what the jury is going to be fixated on. And ultimately, no matter how long this long-form guilty plea takes, I think at the end, Mr. Reinking is going to find himself convicted on all 17 counts. Bizarre facts aside.
All right, we'll see how it plays out. Make sure to check out the Law and Crime Network for gavel-to-gavel coverage. When we come back, the Biden administration drops its COVID vaccination regulation after the Supreme Court blocked the mandate. What the Occupational Safety and Health Administration says is next. That's ahead on Law and Crime Daily. Welcome back to Law and Crime Daily. In COVID news, the Biden administration drops its vaccination mandate after a monumental Supreme Court defeat. Effective Wednesday, the Occupational Safety and Health Administration, better known as OSHA, says it's pulling vaccine and testing requirements. Earlier this month, SCOTUS blocked the mandate after the Biden administration called for all employees to be vaccinated or submit to weekly COVID-19 tests for companies with more than 100 employees. SCOTUS ruled OSHA overstepped its authority by issuing the mandate under its emergency powers. The Labor Department says OSHA will now ask courts to dismiss lawsuits relating to the mandate. Those lawsuits stem from Republican-led states, private businesses, national trade associations, and religious groups in response to the vaccine requirement. A statement from the Labor Department says, in part, quote, OSHA is evaluating the record and the evolving course of the pandemic. OSHA has made no determinations at this time about when or if it will finalize a vaccination and testing rule. From here, the Biden administration has asked businesses to voluntarily implement the vaccine requirements. Meanwhile, Justice Stephen Breyer announces he will retire from the Supreme Court at the end of the current term. 83-year-old Justice Breyer is the oldest Supreme Court justice. He has served on the court for more than 27 years. Notably, he is one of the 3 remaining liberal justices. Breyer's decision to step down now means President Joe Biden can appoint a successor that could serve for decades. Right now, the court is split 6-3 between conservative and liberal justices. Kirk, OSHA is withdrawing its vaccine mandate. What happens to the pending lawsuits, and what does that mean for businesses?
Well, ultimately, as far as it relates to the pending lawsuits, most of those are going to be rendered moot. The decision, the Supreme Court is the law of the land. The ruling should take care of the bulk of those lawsuits and render them moot. So then it becomes then, with no law guidance, no imposition of mandates, on the businesses. Businesses are going to have to decide for themselves, both in terms of their relationship to the public, how they want to present themselves on what has become an exceedingly political issue, and how they want to protect their workers. Do they want to impose that on their workers so that they can maintain their staff? We see a lot of businesses with shortages, et cetera. So now it's going to be up to each and every business to decide how they want to proceed.
We'll see how that plays out state by state and city by city. Terry, talk to us about Justice Breyer's legacy and how his retiring may change SCOTUS for decades to come.
Oh, it will definitely change the whole Supreme Court. Listen, he was and is a brilliant justice. He was appointed by Clinton in 1994. And like you said, he served on the bench for almost 28 years. And the only other justice who has served as long is Clarence Thomas. He served 3 years longer. You can just say that Breyer is considered liberal, although he doesn't like to be announced as being liberal. He thinks it should be apolitical, but he definitely is, along with Justice Kagan and Justice Sotomayor. He wrote a book actually on making our democracy work. That is his legacy. He says basically, whether you have laws or rules, doesn't matter, the people have to do it.
All right, we'll see how the Supreme Court changes over the course of the next coming weeks. Thank you both, and thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.